May it please the court. My name is Madison Brown and I'm acting on behalf of Lynn Bako. That is Lynbako. We submit a plea of not guilty due to the inadmissibility of evidence. I respectfully ask Your Honour to exclude any evidence committed by my client on the basis of the Christie discretion and public policy discretion of Bunning and Cross. To admit evidence given by my client in a state of obvious disadvantage, being that of a 14-year-old child, pursuant to Section 21A of the Queensland Evidence Act, hereafter known as the Act, would be unfair, pursuant to Section 130, when nothing in this Act derogates from the power of the court to exclude evidence if the court is satisfied that to admit that evidence would be unfair. Per the Christie discretion and Aaron Hasler ex parte Attorney General, I argue that the evidence admitted against my client is insubstantial in that no one saw my client breaking into the school, and the mere fact of her running away has the tendency to be highly prejudicial as it implies guilt, yet insubstantially probative as no one actually saw she committed the crime. On this ground, I seek that this evidence against my client be excluded. My client was subject to questioning pre-trial in a manner inconsistent with Queensland legislation. Per the first consideration of Bunning and Cross public policy discretion, pre-trial questioning was a deliberate breach of the law by the officer, contravening Section 7 of the Police Powers and Responsibilities Act 2000, hereafter known as the PPRA. My client is a young Indigenous female, and the relevant steps of Section 420 of the PPRA ought to have been well known and followed. Section 7 is in place to ensure the jobs of officers are correctly complied with. In this instance, the law has not been appropriately followed, as is the requirement of the final Bunning and Cross public policy discretion consideration. Firstly, Your Honour, I direct your attention to Section 420 of the PPRA relating to questioning of an Indigenous child. My client has not been given an opportunity to arrange a lawyer after her arrest, but was subject to questioning by the officer. The officer did not notify my client that she was entitled to a legal aid representative before questioning, nor, I argue, that assigning a legal aid representative post-interview and setting of a trial date falls within the requirements of Section 420, subsection 2B of the PPRA. On this ground, I seek that any admission made by my client without a legal aid officer present was contrary to her rights and should therefore be excluded. Further to the PPRA, per Section 420, subsection 4, a police officer must not question a person until that person has had a chance to speak with that support person in a setting where the conversation cannot be overheard and the support person can be present during questioning. Officers question my client after the arrest and before any such contact with the support person could be made. It is insufficient that a person who is unfamiliar to my client was provided after the questioning and admissions had taken place. Regarding the third consideration of the Bunning and Cross public policy discretion, the pre-trial questions cannot reasonably be considered a genuine response to a pressing circumstance, in that my client had already been arrested and there was no imminent danger to evidence destruction. The police were simply cutting corners, and on this basis, I submit that the admissions made by my client be excluded. Secondly, Your Honour, I submit that questions used by the officers to obtain admissions of guilt were improper questions pursuant to Section 21 of the Act. Per Section 21, subsection 1 of the Act, a court may disallow a question put to a witness if the court considers the question to be improper. As my client was not given a reasonable opportunity to speak with a legal aid representative or a support person, she was not aware that she was not obliged to answer any questions deemed improper. I ask you to consider the following in determining whether the questions asked were improper. Level of understanding. As my client is a 14-year-old child, she has a significantly lower level of intelligence, both in common sense and of the law, to that of a police officer. On these grounds, asking wordy questions to confuse and trick my client into an admission of guilt of crimes these officers were merely speculating she committed are improper questions. Cultural differences. It is customary for young Indigenous children not to look their elders in the eyes when being spoken to. My client, when answering questions, per her culture, was avoiding eye contact. The officer demanding my client look at him and answer draws a clear inference that he was unaware of their cultural differences. Thus, their actions were improper, further intimidating my client into a false admission. If an admission is false, its cogency to a matter is questionable. As my client was intimidated into a false admission, this evidence cannot be considered vital to the charge at hand, pursuant to consideration 2 of the Bunning and Cross public policy discretion. Finally, Your Honour, I ask you to consider the definition of improper question, being a question that uses inappropriate language or is misleading, confusing, annoying, harassing, intimidating, offensive, oppressive, or repetitive. I argue that the questions asked by the officers contain elements of all of the above, such as repetition of dates of other non-related offences, lengthy and unclear questions, intimidating body language, such as continuing questioning when my client was visibly uncomfortable, and suggestive questioning, such as, are you agreeing that you committed these crimes? And Lynn, someone last month tried to burn down the grade 5 class of this school. Was that you who did this? On these grounds, Your Honour, I further urge that the admissions made by my client be excluded pursuant to Section 21 of the Act. Your Honour, I respectfully submit that any submissions made by my client were made in circumstances contrary to Queensland law and obtained illegally. I respectfully submit that the Christie discretion of Bunning and Cross be applied to exclude any evidence unfairly obtained by my client. Likewise, I argue the severity of the charge against my client is minimal per the fourth consideration of Bunning and Cross public policy discretion. Therefore, Your Honour, all admissions made by my client are appropriately subject to a relevant exclusionary discretion and should therefore be excluded, thus making this case neato.